This is in the District Court of Butler County, Kansas, case entitled in the matter of the marriage of Caitlin Kayleen Winton and Brandon Allen Winton, case number 2022 DM 340. Caitlin appears separately by Zoom from her attorney, Jennifer Lotz. Desiree Smith appears with Brandon Winton. This matter comes before the court at this time for status conference, essentially. The court's docket notes indicating that the matter came before the court last on September the 12th. Ms. Smith announced that she was changing firms. Domestic conciliation was ordered with a 50-50 cost split with Christina Retzlaff. Property and debt proposal was to be sent by Jennifer Lotz within 21 days. Domestic conciliation to be paid within 14 days. Smith was to draft the domestic conciliation order and the journal entry stemming from September 12th proceedings, and a review hearing was set for today. Counsel, what is the status of domestic conciliation?
Your Honor, they have completed domestic conciliation. They have reached an agreement. There were some issues in the last 24 hours, to my knowledge, where there was a paragraph added to the agreement. I haven't got approval from my client yet to agree to that paragraph. Otherwise, property, debt split, custody, and parenting time is all agreed on at this time. The subsection is for minor children not to have contact with Brandon, who is the boyfriend of Miss Winton. Apparently, there was a DV charge or a DV pickup, at least, within the last 24 hours. I don't know if the children were present, but they are requesting for the minor children not to have contact with Brandon.
Okay, this individual they're not to have contact with is also named Brandon?
Oh, I'm sorry. No, I'm sorry. JB is his name. I've got him confused. My apologies.
Okay. Not having contact with her father was going to be a little bit problematic, I would think.
Yes, yes.
All right. Okay. Is there going to be an objection to that addition?
The hearing opens with something that looks routine on paper, but is actually a test of whether months of negotiation will survive the final stretch. The judge immediately focuses on unfinished obligations instead of emotions, showing that procedural discipline matters just as much as the agreement itself.
I have not had a chance to talk to Caitlin yet. I don't know if there will or not. I have sent a text in. She could text me and I could let you know ASAP.
Your Honor, it's our understanding that Ms. Winton filed a protection from abuse order or action against JB this morning. So the only reason we added it was because they agreed via text to add it, because she's filing a protection from abuse action against him. So it was an agreement of the parties. I've submitted the journal entry to the court as a proposed order so the court can see what the proposal is. That was fact filed this morning. My client has already signed it.
What do you mean fax filed?
Since we can't file online, we faxed it in this morning. Okay. So we filed it this morning as a proposed order.
You filed it in the case as a proposed order?
Yes, we filed it under the proposed order tab so the court could just see what was in the journal entry, since we didn't have her signature today like we were hoping. But we're hoping to finalize today if there's no objection. That was the plan by both of us yesterday.
All right. Again, I'm not sure what you mean by the proposed order tab. Electronic filing's still down, so I'm not sure. Probably should have just sent it to my assistant, but okay. Well, I don't have it before me.
Okay, well, there's an agreed journal entry to my knowledge.
All right. All right. What I think I'm inclined to do is go ahead and pause recording and broadcasting and set up a breakout session between Caitlin and Jennifer. Give her an opportunity to discuss this language that apparently is an additional paragraph that's been proposed. She apparently hadn't had a chance to talk to her client about it. I want to see if we can try to get this matter resolved this morning. So I think I'll give them an opportunity for a private session, and then we'll go back on the record. So Desiree, if you and your client will just be patient, we'll try to resume proceedings here in just a few minutes. If we can. Following a recess, we resume proceedings in the Winton matter, 22 DM 340. Counsel and the parties appearing as before. It's the court's understanding that a comprehensive agreement has now been reached, and that the petitioner is now ready to present evidence in support of the petition. Is that correct, counsel?
Yes, Your Honor.
I show Caitlin was the original petitioner in the case. She'll need to go forward with evidence in support of her petition for divorce. Counsel, I would like you to kind of highlight the agreements in this case. I don't need to know every holiday provision or where every fork and spoon goes, but I would like you to cover what custodial arrangement is now going to be asked to be ordered, child support, alimony, any real estate allocation, and any monetary judgments, of course, that the court might be asked to grant. So, Ms. Lotz, I'm going to have your client sworn in at this time. Caitlin, if you would raise your right hand, I will administer an oath to you. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Okay. You may question the witness, Ms. Lotz.
Thank you, Your Honor. Can you please state your name?
Caitlin Winton.
Okay, and you currently married to Brandon Winton?
Yes.
Okay, and do you have children together?
Yes.
Okay, how many children do you have?
We have 2 children.
Names and ages, please.
Paisley Winton, she's 9, and Trex Winton, he's 8.
Okay, and do you agree that you filed a petition for divorce on August 19th of 2022?
Yes.
Okay, and do you agree that you and Brandon have reached an agreement regarding custody?
Yes.
And parenting time? And do you agree that you are incompatible and wish to have the court order a decree of divorce?
Yes.
Let's talk about your custody agreement. Can you tell us, do you recall your custody agreement?
Yeah.
Okay. And who was granted primary residential custodian?
He is currently.
Okay. And
The private discussion ends. The courtroom atmosphere shifts from negotiation to verification. The judge no longer acts as a mediator trying to bridge disagreement. Instead, the court becomes a gatekeeper, responsible for making sure every promise can legally stand.
he is currently for how long?
For at least 3 months.
Okay. And at the end of 3 months, does custody, I'm sorry, you say 3 months, is that a hard and fast 3 months, or is it contingent upon something?
Contingent upon the family therapist.
Okay.
Saying yes or no.
Is it true that you agreed that the family therapist will recommend that parties move to shared custody once she recommends shared custody?
Yes.
And are you in agreement with that?
Yes.
Okay, let's talk about for the next at least 3 months. Can you tell us what custody you and Brandon have agreed to as far as parenting's made?
Every other weekend, I get the kids from Friday after school to Sunday night at 6 p.m. And then, yeah.
Okay. And then once, if the family counselor recommends shared custody, what custody agreement have you guys agreed upon?
I will have the kids every Monday, Tuesday. He will have the kids every Wednesday, Thursday, and then we will rotate weekends, and Friday plays into the rotated weekends.
Okay, so it's a 2-2-3 schedule, correct?
Yeah.
And have you guys agreed on child support once it's moved to shared custody?
We've agreed to just pay 50% of all child expenses together and no child support.
So you guys split the direct expenses for child support, is that correct?
Yeah. Yes, and anything over $100 has to be reviewed by the other parent before it's just bought.
Okay, and you have reviewed the proposed order between you and Brandon, is that correct?
Yes.
And you have agreed to a holiday parenting plan?
Yes.
Let's move on. Judge, do you want me to go into the property and real estate?
Certainly the real estate.
Have you and Brandon made agreements as far as the marital home?
Yes.
Okay, tell us what that entails.
I'm not going after anything for it.
You agree that Brandon will receive the marital home free and clear of any lien or right of you, correct?
Yes.
And as far as property settlement, have you come to an agreement?
Yeah, I have all the things other than the deep freeze out of the house and my childhood pictures out of the house that I get.
So is it true that you've already split all property except for the deep freeze and childhood pictures?
Yes.
Okay. And you will be receiving the deep freeze and childhood pictures from Brandon?
Yes.
There was a clause that was added this morning regarding JB Hall. And we reached an agreement on that. Can you tell us what that agreement is?
That he's not allowed. There's a no contact order between him and my two children, Paisley and Trex, for until the family therapist says that it's a good idea or it's okay, or up to a year.
It wasn't our agreement that there'll be no contact with the minor children of you and Brandon for 12 months. Is that correct?
Yes.
And you agreed to that?
Yes.
Okay. And as far as paying off the real estate, whose debt does that now become?
Brandon's.
Okay. And is it true that you were going to pay for your own vehicle and your vehicle insurance?
Yes.
Okay. And do you have any credit cards or other debt that is owed jointly?
Not jointly.
Okay. And anything with your name solely on debt will be acquired by yourself. Is that true?
Yes.
I have no further questions, Your Honor.
All right, Ms. Smith, do you have additional questions for this witness?
No, Your Honor.
All right. Slots, do you intend to present any further evidence?
I do not, Your Honor.
All right. Ms. Smith, do you intend to present any evidence today?
The newest provision becomes one of the most significant parts of the entire agreement because it prioritizes future safety over present convenience. Restricting contact between the children and a third party is not presented as punishment. It functions as a protective measure built around caution and professional oversight.
No, Your Honor.
All right. Court has considered the testimony as provided to the court today and the content of the file in this case, and the court does determine, first of all, that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent. On the legal ground of incompatibility, the marriage of the parties is hereby declared by the court to be dissolved. The court further finds that the parenting plan that's been agreed upon certainly appears to the court to be consistent with the best interest of the minor children. The court will approve that plan and make that plan the orders of the court, including their agreement on child support. There does not appear that there's been any request for spousal support by either party. Therefore, no spousal support will be granted. The court approves the parties' agreement regarding the real estate in this case. Apparently, the court is not going to be asked to make any monetary judgments in this case. Court finds overall that the division of property and debt is fair, just, and equitable. The court approves parties' agreements and will make those the orders of the court in all material respects. I'll point out to the parties that under the laws of the state of Kansas, you're not divorced based on this oral pronouncement from the bench, but rather when the decree of divorce is finalized, submitted to the judge signs it, and then that decree is filed with the clerk of the district court. It is the filing of your divorce decree, which is the act that divorces you under Kansas law. And then for a period of 30 days thereafter, neither one of you should try to remarry. Any marriage you would attempt to enter into during that 30-day period would be voidable under Kansas law. So wait at least 30 days past your decree's filing date to attempt to enter into any new marital relationship. I hope you two can continue to work together for the best interests of your kids. you're going to be co-parenting for what looks like at least 10 years or so. So I hope that you can always talk to each other about what's best for the kids and do what's best for the kids. You're off to a good start at this point. All right, Ms. Smith, because I think there was some minor modification made to the proposed decree this morning, I trust that you'll be adding whatever additional language is necessary and then submitting the decree on paper to the court for eventual filing. Is that correct?
Yes, Your Honor.
All right. Thank you for your efforts to get that done as soon as practicable under the circumstances. All right, Ms. Loss, is there anything further we need to address today?
No, Your Honor, thank you.
Ms. Smith, anything further at this time?
No, Your Honor. Thank you.
Very well. And if there's nothing further, the Winton matter will currently be in recess.
One of the most valuable lessons from this hearing arrives after the major decisions have already been made. The judge carefully explains that the spoken ruling does not legally end the marriage. That distinction surprises many people outside the legal system because courtroom announcements often appear final. In reality, the signed and filed decree carries the legal force, not the oral decision from the bench. The additional warning about waiting before entering another marriage reinforces how procedural details can have real legal consequences. These instructions are not routine formalities. They protect the parties from creating unnecessary legal complications immediately after resolving their divorce. It is another example of the court focusing not only on ending the current dispute, but also on preventing avoidable problems after the hearing concludes. The closing moments reveal the judge's broader objective beyond paperwork and legal orders. By encouraging continued cooperation, the court acknowledges that the divorce may be ending, but the parenting relationship is only entering a different phase. The reminder that years of co-parenting remain shifts attention away from the courtroom and toward everyday decisions that will affect the children far more than this hearing. Even the request to promptly revise and submit the final decree reflects the importance of completing the legal process correctly instead of assuming the difficult work is already finished. The hearing ultimately stands as an example of how successful family court outcomes depend less on dramatic courtroom victories and more on structured agreements, responsible decision-making, and a willingness to place long-term family stability ahead of short-term personal conflict.